import there basically is to define tribunals, and what I can see there is on the second paragraph on page 4, which says that by nature of their tribunals, tribunals are created by statute, exercise quasi-judicial functions, and carry out their duties in accordance with the law under which they are established, and the principles of natural justice. Usually, tribunals are set up to handle administrative issues that cannot be handled conveniently by the ordinary courts. Tribunals are usually set up to resolve disputes between public authorities and individuals that may arise in the course of implementation of policies or enforcement of laws. Currently, there are a number of tribunals created in pursuant to provisions of the Constitution of the Republic of Uganda, 1995, and other tribunals created through other enactments of Parliament. And here below, we bring for you the constitutional tribunals enacted by command of the Constitution, and then constitutional tribunals that have been enacted by an act of Parliament. That is page 4. Then we go to page 5, and then we go straight to page 7. Let's go to page 7 and see what is there. Now, page 7, we go to general analysis, observation, findings, and recommendations of the committee. This part is of analysis. This part of the analysis examines the bill and considers the provisions being amended, the proposed amendments made to the provision, the effect of the amendments, including the provisions' legality, effect, and effectiveness in light of other provisions or any other law, existing public policy, if any, court decisions, and mischief it intends to cure. The analysis is classified in thematic areas the bill proposes, after which a recommendation is stated. The matters are divided into preliminary matters and substantive matters raised by stakeholders during their interaction with the committee. Now, under preliminary matters raised by the stakeholders and members of the committee, there arose the issue of constitutionality of the bill in light of Article 152. And I want to read this one, Honourable Speaker, for the members to understand, because it is a matter of contention by the minority report. During the consideration of the report, a number of preliminary matters were raised relating to the constitutionality of the bill, public consultation, application of the bill, and the policy considerations and other matters which are highlighted below. Constitutionality of the bill in light of Article 152. Stakeholders raised the preliminary matter relating to the constitutionality of the bill in regard to the proposal to merge the Tax Appeals Tribunal with the Electricity Disputes Tribunal. The proponents of this objection argue that the proposal to merge the Tax Appeals Tribunal with any other tribunal as proposed in the bill will infringe Article 152 of the Constitution. According to the proponents, Article 152(3), Clause 3 of the Constitution envisages an independent Tax Appeals Tribunal whose only role is to settle tax disputes. They further urge that the Tax Appeals Tribunal cannot be merged with any other tribunal and should remain independent with a single mandate to settle tax disputes. The committee has examined the assertions made by the stakeholders, and members of the committee find no merit in them. In arriving on this finding, the committee examined Article 152 and found that the bill in its current form does not infringe any constitutional provisions, especially Article 152, Clause 3 of the Constitution, as alleged. Article 152 is reproduced below, and Article 152, the head note is taxation. No tax shall be imposed except under the authority of an act of Parliament. That is Clause 1. Clause 2, where a law enacted under Clause 1 of the article, of this article, confers powers on any person or authority to waive or vary tax imposed by that law, that person or authority shall report to Parliament periodically on the exercise of those powers as shall be determined by law. Now, Clause 3, which is the matter of contention. Parliament shall make laws to establish tax tribunals for the purposes of settling tax disputes. The committee finds that Article 152, Clause 3, imposes an obligation on Parliament to establish tax tribunals for purposes of settling tax disputes. The provision requires the establishment of tax tribunals and the settlement of tax disputes by tribunals as so established. This provision merely obligates Parliament to provide a mechanism for settling tax disputes. The mechanism must be a tribunal and not a cohort of judicature or any other forum. The provision does not require that the settlement of tax disputes must be done by a single tribunal whose only function is to adjudicate on tax disputes, as alleged by the persons objecting to the bill. Indeed, Clause 3 of Article 152 is crafted in plural and envisages the appointment of more than one tribunal for settlement of tax disputes. The provision does not also require that the name of the tribunal envisaged in the provision be Tax Appeals Tribunal. The committee finds no cap on the jurisdiction that may be exercised by the tribunal created pursuant to 153 Clause 3 of the Constitution. The tribunal envisaged under Article 152 can handle tax disputes and any other disputes that Parliament may confer into it. And the argument proceeds, but that's the crust of it. The recommendation that the committee recommends that the argument that the bill infringes Article 152 be rejected. Policy considerations. The committee also received submissions from a number of stakeholders whose opinion was that the bill is premised on a wrong policy, since the cabinet decision taken on 22nd February was contained in cabinet minute number 43, did not recommend the merge of Tax Appeals Tribunal with the Electricity Disputes Tribunal, as alleged in the memorandum of the bill. The proponents of this argument opine that the bill is hinged on a falsehood, since the cabinet has never recommended the merger of Electricity Disputes Tribunal with the other tribunals in Uganda. Our finding is that RAPEX is a government policy as passed in the 2021 Cabinet Minute Extract, which I have given you, and therefore we find no merit in this argument. We recommend the committee recommends that the assertion that the policy for rationalization of government agencies and public expenditure does not extend to Electricity Disputes Tribunal is rejected. Consultations of affected tribunals. Various stakeholders made the assertion that government did not consult them, or that the consultations were insufficient, or that their views were not taken into consideration during the consultation process leading to the introduction of the bill. The committee was informed by the representatives of the Tax Appeals Tribunal and then members of the Electricity Disputes Tribunal that whereas they were consulted during the formulation of RAPEX policy, their views were not taken into account. The committee was informed that Tax Appeals Tribunal and the Electricity Disputes Tribunal were both objected to the merger, but these views were rejected by Cabinet. In responding to this matter, the committee is aware that Article 1 of the Constitution guarantees the sovereignty of the people of Uganda. The committee is also aware that there is no legal requirement for public consultation because during the conceptualization of policy laws, and it's merely good governance and good practice to consult the public. All there is in the Constitution on public participation is in the national objectives and directive principles of state policy, and the provision of Constitution for a bill to be sent to the committee for conducting a hearing. In the absence of a law that lays down a structure modus operandi for public consultation and participation, the committee is aware and was informed that the government consulted widely the affected agencies, and some indeed submitted their views and responses to the proposals to the bill. The committee was informed that indeed the Tax Appeals Tribunal and the Electricity Disputes Tribunal views were sought on the proposed merger through the airline ministries, and we are informed that the decision to merge them had been made by Cabinet. And so we conclude that the committee is satisfied that there was sufficient consultations carried out by government during the conceptualization of the RAPEX policy. Application of the bill. Various stakeholders opined that the bill should be rejected on grounds that its application is not clear and it infringes on various articles of the Constitution, since it rationalizes various tribunals established or envisaged in the Constitution. The committee has examined this assertion and finds that whereas the bill does not clearly stipulate the tribunals it seeks to rationalize, save for the Tax Appeals Tribunal and the Electricity Disputes Tribunal, this is not a ground for total refusal of the bill in its entirety, since the Committee of Parliament are empowered under Rule 129 to propose amendments as the committee deems necessary. The committee notes that the explanatory memorandum states that the intention of the bill is to merge Tax Appeals and Electricity Disputes Tribunal into one tribunal called the National Tribunal, which shall adjudicate all disputes subject to a tribunal. But Clause 43 and 44 of the bill And clause 43 and 43 of the bill emphasizes this intention by repealing the Tax Appeals Tribunal and dissolves the Electricity Dispute Tribunal as well. That as it may, clause 43 suggests that the intention of the bill goes beyond just merging those two agencies. Clause 43 provides that where any act provides for the establishment of a tribunal, the national tribunal shall be taken to be the tribunal established by the act. Clause 43 has the effect of transferring the functions of all other tribunals envisaged or established under any act or under any other law to the national tribunal. Similarly, clause 16 of the bill can be interpreted as extending the jurisdiction of the bill to tribunals that are established under any other act of parliament. The committee has examined the bill and other relevant laws applicable to the subject matter and is of the considered opinion that the confusion as to the application of the bill and the proposed extension of the bill to all other tribunals directly established or envisaged under other laws has constitutional and legal ramifications, which might affect the legality of the bill if not amended. The first challenge will be constitutional, since clause 42 will have the effect of amending the constitution to transfer the national tribunal to the functions of all tribunals created and envisaged under the constitution. It should be noted that the constitution creates directly or empowers the establishment of the following tribunals. We list the tribunals that are established under the constitution. For example, there is a tribunal appointed by the president under Article 60 of the constitution for the removal of a member of the electoral commission. There is another tribunal, for example, established by the chief justice under Article 64 of the constitution to hear and determine a dispute between the electoral commission and any other person aggrieved by a decision of the electoral commission in respect of demarcation of constituencies. And we list all the constitutional tribunals envisaged under the constitution. Now, clause 42 appears to suggest that the above tribunals created or envisaged under the constitution will be dissolved and their functions taken over by the national tribunal. If this is the intention of clause 42, then clause 42 amends the constitution indirectly, a matter that will open the bill to legal challenge for contravening Article 259 of the constitution. It is therefore the committee's considered opinion that unless clause 42 specifically exempt constitutional provisions from the application of the bill, clause 42 is likely to be challenged for contravening all articles of the constitution that directly create tribunals or provide for the appointment of a tribunal in specified circumstances. And so we propose that this bill restricts itself to tribunals that are not envisaged under the constitution as we have listed them. They are listed here: the Tax Appeals Tribunal, and then we have the Public Procurement and Dispose of Public Assets Appeals Tribunal, established in Section 108 of the Public Procurement Dispose of Public Acts. The Electricity Disputes Tribunal, established by Section 97 of the Electricity Act, Cap 157. The Insurance Appeals Tribunal, continued in existence under Section 135 of the Insurance Act, Cap 191. The Uganda Communications Tribunal, established under Section 61 of the Uganda Communications Act, Cap 103. The Retirement Benefits Appeals Tribunal, established under Section 83 of the Uganda Retirement Benefits Regulatory Authority, Cap 232. The Capital Markets Tribunal, established under Section 131 of the Capital Markets Authority Act, Cap 64. The Seeds and Plants Tribunal, established under Section 16 of the Seeds and Plants Act, Cap 41. And our recommendations that the committee recommends that the bill should be amended to restrict the application of the bill to tribunals created under acts of parliament other than the constitution. Substantive matters, page 15, substantive matters on the contents of the bill. Those were preliminary matters. Now, the issue of mergers. The intention of the bill is twofold. The first intention is, as communicated by the memorandum, and clause 43 and 44 is to merge the Tax Appeals Tribunal and the Electricity Disputes Tribunal into one national tribunal called the National Tribunal, which shall adjudicate all disputes subject to settlement by a tribunal. The second intention is to abolish all the other tribunals in Uganda and transfer the functions that have hitherto been performed by all other tribunals to the National Tribunal. This intention is communicated by Clause 42 of the Bill, which is to the effect that where any act provides for the establishment of the tribunal shall be taken to be a tribunal established by the Act. This, in essence, rationalizes all other tribunals in Uganda. The tribunals affected by the bill, I've already listed them. I've already listed the tribunals that are going to be affected by the bill. So I will go to page. I'm now on page 18, and our decision on mergers. The committee received the views and opinions on the proposal to merge the tribunals. Those in support of the proposal aver that the merger will relieve the government of financial drain in its resources and the burden of wasteful administration and expenditure, and facilitate efficient and effective service delivery and promote coordinated administrative arrangements, policies, and procedures. Those who are opposed to the merger aver that the energy policy of Uganda, which proposed the establishment of Electricity Tribunal, supersedes the RAPEX policy, and that the Electricity Disputes Tribunal is a key component of the electricity sector and deserves to be left as a standalone. The other issues raised include disruption in the performance of the mandates of the tribunals, mismatch in the mandates of the different tribunals being merged, limited number of members at the proposed National Tribunal, and restrictive qualifications and experiential requirements for entities that are merging. And our recommendations in respect of that is that in light of the above, the committee recommends that the following tribunals be merged into the National Tribunal. And these ones, I'd already mentioned them, but let me just mention them to be very specific. The Tax Appeals Tribunal established under the Tax Appeals Tribunal Act, the Electricity Disputes Tribunal established by the Electricity Act, the Public Procurement and Disposal of Public Assets Tribunal established under the Public Procurement and Disposal of Public Assets Act, the Insurance Appeals Tribunal established under the Insurance Act, the Uganda Communications Tribunal established under the Uganda Communications Act, the Retirement Benefits Appeals Tribunal established under the Uganda Retirement Benefits Regulatory Authority Act, the Capital Markets Tribunal established under the Capital Markets Authority Act, and the Seeds and Plants Tribunal established under the Seeds and Plants Act. In addition to that, the appointment of members of the National Tribunal should take into account the need to have persons qualified in the subject matter of the tribunals, so that the National Tribunal is constituted by persons who have knowledge in the broader subject matter of the National Tribunal. The other issue is qualifications for appointment and duration of service. And this is critical. I'll read it because members need to understand our proposal here. In Clause 5 and 6 of the bill prescribes the qualifications and terms of service of a member of the tribunal. Clause 5 requires the person that may only be appointed as a member of the tribunal if the person is of high moral character and proven integrity and has not been convicted of any offense involving moral turpitude. The provision further requires that the member must possess qualifications in taxation, finance, accounting, or law, or such other qualifications the minister may by statutory instrument prescribe. Clause 6, on the other hand, provides that the chairperson and other members of the tribunal serve for 3 years and are eligible for reappointment. The committee has examined the proposals contained in Clause 5 and 6, and it is of the considered opinion that some of the aspects contained in the provisions need to be rethought. For instance, the proposal to bar persons who have been convicted of any offense involving moral turpitude should be rethought, since the offenses falling under the category of offense involving moral turpitude are difficult to determine. Using the phrase moral turpitude will affect the effectiveness of the provision, and since such offenses involving moral turpitude cannot easily be defined and determined. And we go on to say it should be noted that whereas the phrase moral turpitude, our argument here, honorable members, is that we seek to omit the requirement that we seek to remove the idea of excluding someone on the grounds of moral turpitude, because their definitions have been problematic in the courts of law. And our recommendation that offenses involving moral turpitude in Clause 5 should be deleted, and in Clause 6, the provision should be amended to impose term limits. And then on the issue of term limits, the proposal was that a member could be appointed for 3 years and then reappointed without putting term limits. We are proposing that members of the board be appointed for only 3 years with a further term of only 1. So we are putting a term limit. Page 23, appointment of the judge to the tribunal and effect on his or her tenure as a judge. Clause 3 of the bill provides that the chairperson of the National Tribunal provides for the chairperson of the National Tribunal and requires that he or she is appointed by the minister in consultation with the chairperson of the Judicial Service Commission and the minister responsible for public service. A person is not qualified to be appointed chairperson of the National Tribunal unless he or she is qualified to be appointed a judge of the High Court. This clause limits the appointment of the chairperson of the tribunal to either a person who qualifies for appointment as a judge of the High Court or a sitting judge of the High Court. In a situation where a sitting judge is appointed, clause 72 of the bill guides that the appointment of a judge as a person shall not affect his or her tenure of office as a judge, or his or her rank, title, status, procedure, salary, and allowances, or other rights or privileges as the holder of the office of the judge of the course of judicature. And for all purposes, his or her service as chairperson shall be taken to have been service as holder of the office of such a judge. The committee has considered the proposal contained in clause 72, and it is of the considered opinion that this clause should be rethought in light of the limitations imposed on a judicial officer who serves outside the judiciary under section 20 of the Administration of Parliament Act. Administration of the Judiciary Act, Cap 4. Parliament Act. This should be judiciary. We shall clarify. Section 20 of the Administration of, it is the Administration of Judiciary Act. The document says Parliament, but it is Administration of Parliament, the Judiciary Act. Section 20 of the Administration of the Judiciary Act requires that where a judicial officer is appointed to an institution outside the judiciary, the judicial officer applies for leave of absence without pay from the judiciary. Section 20 of the Administration of Parliament Act requires that where a judicial officer is appointed to an institution outside the judiciary, the officer requires for leave of absence without pay from the judiciary. The maximum period a judicial officer can serve outside the judiciary is 3 years. This means that a judicial officer who is appointed to the tribunal must apply for leave from the judiciary, and emoluments of that judicial officer are suspended for the duration of his or her service outside the judiciary. Furthermore, Section 20, paragraph 6 requires that the period of service of the judicial officer outside the judiciary is not counted as part of the judicial officer's service in the judiciary and is discounted in computing retirement benefits. Clause 7 of the bill therefore contradicts Section 20, 1A and 6 of the Administration of the Judiciary Act insofar as it maintains the salary, allowances, other rights or privileges as enjoyed by a holder of the office of the judge of the courts of judicature. Yes, yet these are affected by the provisions of Section 20, 1A of the Administration of the Judiciary Act. It deems the service of the judicial officer outside the judiciary to be service in the judiciary, yet this is barred in Section 20, paragraph 6 of the Administration of the Judiciary Act. The committee is of the considered opinion that since there is a great deal of backlog in the courts of law, there is need to bar the appointment of serving judicial officers from the tribunal so that the normal operation of the courts is not affected by the appointment of serving judicial officer on the tribunal. Recommendation: in light of the above, clause 7.2 should be deleted and instead clause 3 be amended to bar serving judicial officers from being appointed on the tribunal since it disrupts the administration of justice in courts of law. Transition to the National Tribunal. Clause 41 of the bill provides for transitional matters, and it requires that the bill applies to decisions made before the bill is commenced. Whereas this provision is necessary since it will allow for the filing of the tribunal for review, decisions that were made before the tribunal came into force, it falls short of addressing the issue as to what happens to matters that were filed with the tribunals that are being dissolved, for which the relevant tribunals have not rendered a decision. The committee finds this to be a major stumbling block since at the moment most of the tribunals that the committee interacted with are grappling with the case backlog due to either delay in appointing members of the relevant tribunals, as the case is with the Tax Appeals Tribunal, or as well as lack of quorum in some other tribunals as the Electricity Dispute Tribunal, arising from expiration of contracts of the current members of the tribunal. The committee was informed that currently 40 cases are filed with the Tax Appeals Tribunal every month, while the backlog stands at 600 cases yet to be determined. In the case of the Electricity Tribunal, the tribunal has a backlog of over 500 cases arising from non-renewal of contracts of the serving tribunal members, which expired in July. This state of affairs also pertains in other tribunals due to operational reasons. In light of the above, the committee finds the proposal in clause 41 insufficient to deal with the backlog currently experienced before some tribunals, and opines that there is need for the tribunals being dissolved to be given adequate time to finalize all the matters before them for a period of at least 1 year from the commencement of the National Tribunal, so that the National Tribunal is not saddled by the case backlog experienced by the current tribunals. This is advisable for mainly 2 reasons, and we give the reasons. Recommendation: in light of the above, the committee recommends that the bill is amended to provide a transition of the matters that are currently pending before the dissolved tribunals in order to reduce the disruption in delivery of justice that may be occasioned by the dissolution of the tribunals without adequate provision for transitional matters pending before the tribunals. In conclusion, Madam Speaker and honourable members, the committee recommends that the bill be passed into law subject to the attached proposals. I thank you very much, and I beg to move.
Thank you so much, Chair. I thought you had a minority report. I thought you had a minority report.
Oh, I now take the singular honor to invite my colleague, member of the committee, the Honorable Jonathan, to present the minority report.
Oh, Chitiwa. Thank you.
Thank you, Right Honourable Speaker, and I thank the chairperson of the committee for inviting me to present this report. Right Honourable Speaker, this is a minority report in dissent of the majority report of the Committee on Legal and Parliamentary Affairs as provided for in Rule 205, Sub-Rule 1 of the Rules of Procedure of this Parliament. The following are the points of dissent. The first.
Yes.
Madam Speaker, thank you. I'm moving under Rule 204, Sub-Rule 2, which says members of committee making the report shall be collectively responsible for decisions contained in the report and shall not debate. I have seen the name of Jonathan on the main report. A few days ago, the Attorney General guided that a signature of a person is also the name of the person. What that does is to raise questions about the authenticity of the report of the majority. How can you have 2 people, one person sign 2 reports? They on the majority report and they also on the minority report. Madam Speaker, under Rule 204, Sub-Rule 3, the rule mandates you to refer this matter to the clerk for investigation so that we establish the authenticity of the report Honorable Baka has been presenting here. Then we will be able to discuss this issue further in the next sitting. So I invite you to exercise the powers conferred on you under that rule to ensure we resolve this matter in a very structured way as dictated in the rules. I thank you.
Honorable Dur, can you present your report?
The first point of dissent under paragraph 2.1, Right Honourable Speaker, is contravention of Article 152 of the Constitution of
I think I'm raising an issue, a question of law.
Yes, I'm saying present the report.
Has an offense been, Is that an illegality or it's not an illegality?
Let him present the report.
Idea on what to do.
Procedure.
Do the rules now apply?
Rule 2041 is very clear. So a report of the committee shall be signed and initialed by at least 1/3. Let him show where Odur has initialed.
Honorable, show me where Honorable Odur initialed in the list of the main report. Initialed. It is talking about initial.
Can I make my case? Rule 204. Rule 204 talks about signing and initial.
You read
and signing according to
2041.
Yes, that's where I am. It says report of a committee shall be signed and initialed by at least 1/3 of all members of the committee and shall be laid on table. I have seen the name of,
Is the initial there?
the initial is not there, but the name according to the auditor, I mean the Attorney General, it is a signature.
What does our rules of procedure say?
It says
Initial.
it says signing, and signing. Attorney General defined it as the name of the person.
Signing and initialed. Jonathan.
Right, Honorable Speaker. Just as a rider, usually when reports are presented, I don't want to bring other matters. That's why I confine myself to the text. But I confirm to you that I did not sign the main report.
Listen to
My only signature is on the minority report, and I want to persuade Honorable Lee that the Attorney General is just a lawyer like one of us. He can misguide the House as they have done before many times. On 2.1, contravention of the Article 152 of the Constitution of the Republic of Uganda. The Constitution of the Republic of Uganda is the supreme law of Uganda and shall have binding force on all authorities. In our opinion, includes Parliament and persons throughout Uganda. See Article 2, Clause 1 of the Constitution. Article 2, Clause 2 of the Constitution supra states as follows: if any other law or any custom is inconsistent with any of the provisions of this Constitution, the Constitution shall prevail, and that other law or custom shall, to the extent of the inconsistency, be void. Madam Speaker, Article 152 of the Constitution provides for taxation, and specifically under Clause 3 states, Parliament shall make laws to establish tax tribunals for the purpose of settling tax disputes. The emphasis underlined is ours. It is important to note that in this article, not only commands Parliament to establish tax tribunals, but also prescribes the nature of tax disputes that can be lodged before the tribunal. The deliberate use of the word tax before tribunal signifies the intention of the framers of the Constitution to baptize it as a tax tribunal. The constitutional provision in Article 152(3) can be contrasted with Article 243, Clause 1, which establishes the Land Tribunal and states as follows: Parliament shall by law provide for establishment of Land Tribunal. Our emphasis is that the naming Land Tribunal means you cannot call it by any other name other than a Land Tribunal. The use of plural rather than singular, in our opinion, was deliberate and purposeful to allow flexibility in allowing Parliament create tax tribunals directly or through delegation to address broad geographical coverages, specific category of taxes, as well as appellant jurisdictions if required. For example, a tax tribunal on the subject matter of rental tax, income tax, or broadly customs versus domestic taxes. In geographical scope, the tribunals could be per each Uganda Revenue Authority district office, region, or even at the border entries like Entebbe Airport, Malaba, Busia, Elego, and Motokula, etc. This would allow government to expeditiously resolve tax disputes and free resources involved to the benefit of both the state and the taxpayers. It is therefore critical to note that taxation is an important tool available to the government for purpose of raising resources to deliver services to the taxpayers. The framers of the 1995 Constitution were alive to this fact, and in their wisdom, which we do not have any doubt at all, gave taxation an entire article of its own under 152 with the heading Taxation. The majority report in paragraph 2 on page 9 states that Article 152 of the Constitution is in plural and envisages a appointment of more than one tribunal for settlement of a tax tribunal, and further finds the tribunal is not tax appeals tribunal. The minority report respectfully disagrees with this position and finds that the use of the plural tribunals in Article 152 clause 3 was used deliberately and purposefully to address the different type of taxes such as those mentioned. It is therefore, Madam Speaker, it is therefore erroneous to imagine that a generalized tribunal such as the proposed national tribunal is the one envisaged in Article 152 clause 3, which sole purpose is to settle tax dispute. The minority report draws the attention of the House to the following paragraphs on page 13 in the majority report. Paragraph 3 states and follows, and I invite members to follow. The majority states the committee has examined the bill and other relevant laws applicable to the subject matter, and it is of the considered opinion that the confusion as to the application of the bill and the proposal to extend the bill to all other tribunals directly or envisaged under the other laws has constitutional and legal ramifications which might affect the legality of the bill if not amended. This is an extract from the majority report. On paragraph 4, it goes ahead to say the first challenge will be constitutional, since clause 42 will have the effect of amending the constitution to transfer to the national tribunal the functions of all the tribunals created or envisaged in the constitution. It should be noted that the constitution creates directly or indirectly empowers the establishment of the following tribunals. These tribunals have been listed by the majority report. I will not go through, but I invite members to note that from A to H there is a direct mention of an article of the Constitution. This is the difference between the tribunals listed as constitutional and those ones listed by enactment. The only reason the majority report lists those as constitutional tribunal is because the Constitution directly creates or empowers the establishment. The majority report correctly observes that the tribunals, including the tax appeals tribunal, is created or empowered by the Constitution and therefore should be on the list of those protected by the Constitution. In fact, apart from the tax appeals tribunal, it can be clearly seen that those listed from B to H do not have any constitutional citation. The majority report is further contradicted when it is listed on page 6 the tribunals created by other enactments, which in their opinion are not protected by the Constitution, to even include A, land tribunals, and B, the tax appeals tribunal. The majority report, having made this observation in an unprecedented turn, decided to shift the land tribunal as listed on page 6 and included it under item H on page 14 as a tribunal protected by the Constitution, leaving the tax appeals tribunal which is a constitutional creature isolated on the list of tribunals created by Acts of Parliament. Our finding: the minority report accordingly finds that the National Tribunal Bill 2024 contravenes Article 152, Clause 3 of the Constitution and invites the House to reject this deliberate position of the majority on the same, which contravenes the Constitution. The second point of dissent is on 2.2, Certificate of Financial Implication. The minority report would like to draw the attention of the House to the Certificate of Financial Implications issued in respect of the bill, to the extent that it only covered the proposed rationalization of the Tax Appeals Tribunal and the Electricity Disputes Tribunal. Indeed, this intention is clearly stated in the Certificate of Financial Implication dated 31st July 2024, and it has been reproduced below. Specific objectives of those certificates: the first is to enable the mainstreaming and rationalization of the Tax Appeals Tribunal and the Electricity Dispute Tribunals and the public expenditure, thereby inter alia relieving the government of the financial drain on its resources and the burden of wasteful administration and expenditure. 2. To facilitate efficient and effective service delivery by delineating the mandates and functions of the Tax Appeals Tribunal and Electricity Disputes Tribunal, thereby avoiding the duplication of mandates and functions. 3. To promote coordinated administrative arrangements, policies, and procedures for efficient and successful management, financial accounting, and budgetary discipline of the Tax Appeals Tribunal and the Electricity Disputes Tribunal, to enable government to play its proper role more effectively and enforce accountability. And lastly, in 4, to restructure and reorganize the Tax Appeals Tribunal and the Electricity Dispute Tribunal by eliminating bloated structures and functional ambiguities. The main point we are making is that the certificate only talks about those two tribunals and not any other tribunal. When it comes to staff laid off and budgetary implications, the two tribunals, 11 staff will be laid out. The cost of their terminal benefit, as stated in the certificate, is 2.746 billion shillings. Expected savings and revenue to government: there will be envisaged savings to government of 11.637 billion expected from the merger of the Tax Appeals Tribunal and the Electricity Disputes Tribunal into one national tribunal called the National Tribunal. The savings arises from scaling down the merged structure of the Tax Appeals Tribunal and the Electricity Disputes Tribunal from 46 to 35 staff. I invite members to follow, because the rest of the tribunals allegedly brought here were never assessed in this certificate. What will happen to those staff and the terminal benefits? A patient and critical analysis of the Certificate of Financial Implication issued by the Minister of Finance clearly shows, for all intent and purposes, that it was issued in respect of the National Tribunal Bill 2024 to ration the Tax Appeals Tribunal and the Electricity Disputes Tribunal into a national tribunal. The Certificate of Financial Implication does not mention anywhere the 5 tribunals, that is the PPDA Tribunal, the Insurance Tribunal, the Uganda Communications Tribunal, the Retirement Benefits Appeals Tribunal, the Capital Markets Tribunal, and Seed and Plans Tribunal. All these were not mentioned, and we find problem with the importation. The minority report rejects the legal engineering of the majority report on the basis that Rule 129, Sub-Rule 4, allows the committee to propose amendments as it determines necessary. The minority submits that such amendments are only allowed within the scope of the bill and not matters extraneous that are plainly on the face of it controversial, and therefore invite the House to reject the same and discard it very far away. It is therefore inconceivable that the majority report, without any plausible justification, decided unilaterally, without due regard to the financial implication involved in rationalizing the 5 tribunals, to recommend to the House the inclusion in the bill in what appears to be an attempt at legislative smuggling. Our finding: the minority report finds that the certificate of financial implications issued for the National Tribunal 2024 was issued strictly in respect of the proposed rationalization of the Tax Appeals Tribunal and the Electricity Disputes Tribunal. Dissent 2.3 is inadequate consultation with the key stakeholders. In the process of analyzing the bill, the committee held discussions with only 4 stakeholders that have been listed: Ministry of Justice and Constitutional Affairs, Uganda Law Development Center, the Tax Appeals Tribunal, and the Electricity Disputes Tribunal. The following tribunals now subject of the bill in the views expressed in the majority are the PPDA Appeals Tribunal, the Insurance Appeals Tribunal, the UCC Tribunal, Retired Benefits Appeals Tribunal, and the Capital Markets Tribunal. The minority observes that the committee did not interface directly or indirectly with the key stakeholders from those 5 tribunals, despite our considered request that they be invited. On matters of taxation, the key stakeholder is the Uganda Revenue Authority. And Uganda Revenue Authority was never invited for the reasons that the committee was out of time. This reason is self-defeating, since the committee was still well within the 45 days from the time, this is 24th September 2024, the bill was referred to us. In other words, we have 2 more weeks to reach 45 days to have consulted on the same. The minority report emphatically rejects the position of the majority that Cabinet already consulted stakeholders during the formulation of the RAPEX policy. Even if this narrative was to be accepted, it is imperative to point out that Parliament and Cabinet are 2 separate and distinct constitutional institutions with different mandates under Article 79 and 111 respectively. Parliament is reminded of the doctrine of separation of powers as well as the independence it enjoys in the exercise of its function. In fact, several court decisions have clearly stated that Parliament is obliged to consult widely in furtherance of Article 8A. I refer you to the case of Male H. Mabirizi Keki Wanoka and others versus the Attorney General Constitutional Appeal number 2 of 2018. Our finding: the minority report finds that the committee did not carry out adequate consultation on the bill, and the key stakeholders proposed to be affected by the bill were not granted opportunity to be heard. Those are the other tribunals listed. 2.4 Transitional provision. The majority report observes that clause 43 of the National Tribunal Bill 2024 proposes to repeal the Tax Appeals Tribunal. This, in effect, terminates the legal life of the Tax Appeals Tribunal and consequently removes from office, Madam Speaker, this, in effect, terminates the legal life of the Tax Appeals Tribunal and consequently removes from office the members of the tribunal. The following provisions for removal from the member of a Tax Appeals Tribunal from office are stated in sections 9, subsection 3 of the Tax Appeals Tribunal Act. A member may be removed from office only for 1. Inability to perform the functions of his or her office arising from infirmity of the body or mind. B. Misbehavior or misconduct. C. Incompetence. And D. Being an undischarged bankrupt. Section 9, subsection 4 of the TAT Act. The minister shall remove a member of the tribunal if the question of his or her removal has been referred to the committee appointed under subsection 5, and the committee has recommended to the minister that the member ought to be removed from office on grounds described in subsection 3. Our finding, Madam Speaker: the minority report finds that the members of the tribunal cannot be removed simply as proposed in the process in the bill as proposed by government, and it may expose government to litigation and financial loss.
Can you continue?
We shall proceed, Madam Speaker.
Madam Speaker, general observation, which is the last. Right Honorable Speaker, before taking leave, the minority report notes that tribunals are specialized courts and are tailor-made for specific purposes, such as the first, removal of office of the following: the president, judges, commissioners, you can extend to others, which is constituted on a case-by-case basis. A tribunal constituted for the purpose of removal of one judicial officer only functions for the purpose of removal of that judicial officer and cannot be extended to remove another person from office. The second purpose of a tribunal is settlement of disputes, such as the tax tribunals for the purpose of taxation. Tribunals are meant to offer quick, informal, and flexible mechanisms for resolving disputes, and the memberships are carefully selected based on unique skills, experience, and expertise. In essence, tribunals are never generalized, as there won't be any difference between the courts of law and the tribunal. A review of all the available literature in the entire world did not return any example of a country with a national tribunal which handles anything and also everything. We now conclude. For these clear reasons, Right Honourable Speaker, the minority report recommends that Parliament does not proceed on the National Tribunal Bill until these findings are addressed. I would like to put on record, Madam Speaker, that this minority report has been duly signed by 3 members, myself, the Honourable Lumu Kizito Richard of Mityana South, of the Democratic Party, and most of you know I am from the Uganda People's Congress in the opposition. And number 3, by Sekito Leko Robert of Bamunanika of the National Unity Platform. The Shadow Attorney General, Honorable Newagaba, highly associated but was not able to sign. The same with the Honorable Hassan Basalera. In effect, JEMA, NUP, DP, UPC, and NRM are part of this. I beg to submit, Madam Speaker.
Thank you so much, Honorable Odur. Honorable members, when you look at the memorandum, you have 2 tribunals. You have the electricity and the tax tribunal. Then when you look at section 42, section 42 gives you, it's more of a supremacy clause. It brings in everything. So I am not sure whether you still want to keep section 42 in this law and move away from your object. That's number 1. Number 2, the aspect of consultation is also a matter that should be answered. And then the other issue is on the financial implication. Yes.
Madam Speaker, let me try to answer a few issues before the Minister comes in. The first one, Madam Speaker, is on the issue of the tribunals as distinguished between constitutional tribunals and tribunals that we are calling those that are passed by acts of parliament. Madam Speaker, in our report.
Yes, procedure matter.
Madam Speaker, I have been in this parliament for a while. And back, by the way, except last term, I have never seen a report on a bill presented and the minority report is presented, and the chair of the main report proceeds to debate the minority report.
No, he's not debating. I am
even answering.
I have asked him specifics. I have asked him specifics. He's not debating.
Yeah, but Madam Speaker, the reason I said this is strange is that traditionally the presiding officer will invite the House to consider both. But the one of minority comes back now to deal with the minority, yet both of them sat there and wrote their reports. Now you will be inviting minority to come and deal with what is answering. So that's why I said, Madam Speaker, that this procedure we have taken is strange, and I am calling you for your guidance.
I am still asking, how did the section 42 get into the bill when the object had two? That's what I'm asking. I want to know that. How was it smuggled?
Mr. Speaker, let me localize myself to that specific issue. How the bill had clause 42. We read the bill, internalized it, and it is true that in the memorandum, the bill talks about two entities.
Two entities.
But when you go into the details of the bill, clause 16 and clause 42 alludes to the fact that all the other issues that will arise under other acts of Parliament, where there is a matter that is referred to a tribunal, it will be this tribunal that we are talking about, that we said to. So for that matter, we had to deal with the bill as it was.
Thank you, Honorable Chair. You know, Honorable Chair, we had some debate. When you look, Madam Speaker, at clause 42, that makes reference to all tribunals established under the Acts of Parliament. Some of those tribunals are actually from the Constitution and were operationalized by the Acts of Parliament. In effect, clause 42 intends to amend the Constitution by infection.
Yes.
And even when you look at Article 152 itself, sub Article 3, the majority report notwithstanding, you are amending the Constitution by adding in what the Constitution does not provide. And I believe, Honorable Chair, you should have considered.
Actually, this is like an ad hoc committee handling constitutional matters. Because when you look at Article 69 of the Constitution, it is talking about the Electoral Commission. So this will also handle that. You get it, eh? You look at section 16 also. Look at section 16. Look at section 16. I'm going to allow the debate, but let's first just finish this.
For the clarification from my senior friend. Madam Speaker, because of that challenge, which my senior friend, Honorable Nwagaba, has alluded to, that's why in the wisdom of the committee, we decided to distinguish those, the tribunals, to exclude those that if we subjected them to this act, they would directly infringe the Constitution. And I can give you the list. For example, if you go to the tribunal for the removal of the member of the Electoral Commission under Article 60, Clause 9 of the Constitution, the tribunal is directly established by the Constitution under Article 69 and Article 60, Clause 9. The tribunal is ad hoc and is appointed by the President. So it is out of our purview. Then there is a tribunal to hear 60, Clause 9. It is appointed by the President. It is out of our purview. Then there is a tribunal to hear and determine a dispute between the Electoral Commission and any person aggrieved by a decision of the Electoral Commission in respect of demarcation of constituencies.
That is on
64, Clause 2. The tribunal is directly established by the Constitution under Article 64, Clause 2. The tribunal is ad hoc and is appointed by the Chief Justice. That one is out of our purview. There is another tribunal to investigate and report to Parliament on the allegation in relation to the removal of the President.
That
if you are
is
impeaching the
Article
President.
107.
Article 107, Clause 4. The tribunal is directly established by the Constitution under Article 104, Clause, and it is ad hoc. And it is appointed by the Chief Justice. That one is also out of our purview. There is a tribunal appointed for the removal of a judicial officer under Article 144, Clause 3 and 4. The tribunal is directly established by the Constitution. The tribunal is ad hoc and is appointed by the President. That one is also out of our purview. There is a tribunal for the removal of the Auditor General under Article 163, Clause 13. The tribunal is also directly established by the Constitution under Article 16. The tribunal is ad hoc and is appointed by the President. That one also is out. There is a tribunal for the appointed for the removal of the Inspector General of Parliament.
Honourable member.
So,
Honourable.
yes.
Honourable Minister, what is hard with you bringing a law with only two, the electricity and then the tax tribunal? Then the other one you bring in constitutional amendments.
But there are two issues of contention here. The first one is that the minority report. Let me conclude.
You want to appease the President?
Thank you, Right Honorable Chair. You know, we had advised the government that if it was to act smart, it would bring a constitutional amendment and delete all those tribunals established under the Constitution. Then come up with a national tribunals bill that will encompass all those bills, including the tax appeals tribunal. You work smarter that way.
Honourable Minister.
Madam Speaker, the Honorable Jonathan Odu, with characteristic ebullience, eloquence, and grandiloquence, has bamboozled many members of this House to run away from the fulcrum of the matter under discussion. The pivot of this matter is rationalization. Sometimes, Madam Speaker, hidden in a forest of words and words that seduce, one can sway opinion, but in reality there is always one or two fulcrums on which something turns, just like a door. It brings to my mind a famous case where a steamship company sued a railway company, saying the railway company, by building a bridge across the river, was undermining business of the ships that moved up and down the river. The lawyer that was acting for the steamship company came and with a lot of verbal artillery addressed court for 1 hour, and then the lawyer for the railroad company came and asked the judge to address his mind to only one issue: whether those who want to move up and down the river have more rights than those who want to move across the river. That was the only question. There was no need for a lot of words. Now let me state the fulcrum. Madam Speaker, the Honorable Jonathan Odu has made it up. Madam Speaker, the Leader of Opposition should quote the rule under which he is moving the point of order. Because the point of order is about breach of the rules. It is not about your feeling. I will only yield the floor when the Honorable Speaker tells me to yield the floor.
Thank you, Right Honorable Speaker. Ladit, kindly have a seat. Right Honorable Speaker, I firstly want to salute Ladit Mao. He was a guild president of Macquarie, and the flowery language he used then, he's using now. However, Right Honorable Speaker, the concerns, and that is where my point of order arises from. We have raised two critical issues which you have asked the Honorable Minister of Justice to address his mind to. Number one, the fact that this amendment seeks to, by extension, amend the Constitution, which is ultra-vires. It has got no place in law. Number two, Section 76 of the Public Finance Management Act adumbrates very clearly what a certificate of financial implication ought to be. I have a copy of the certificate of financial implication, and as our colleague has clearly stated, it is talking about two tribunals. In your case, you're seeking to deal with many tribunals. That means the certificate of financial implication is defective. Right Honorable Speaker, what you asked Honorable Mao to address us on is those two issues. The amendment of the Constitution by effect, by implication. Number two, the certificate of financial implication. Honorable Mao is taking us in circles. Is he in order, Right Honorable Speaker, to meander as opposed to addressing this House on the two critical issues, two matters of law? And he is a lawyer, Right Honorable Speaker. Is he in order?
Honorable members, when you look at section 16 of the bill, the National Tribunal to review decisions. Any person who is aggrieved by any decision made under this act, subject to review by the National Tribunal, may apply to the National Tribunal for review of a decision, including that of that is a correction of the Constitution. I would request the minister that since there is a drafting problem, so we could have something drafted better, and we will still accommodate you here. I am just requesting that if we could have it taken back for redrafting. Yes, Honorable Minister.
I'm a disciplined citizen of the Republic of Uganda. I'm not immune to logic either. In particular, I'm not immune to common sense. I have strong opinions about those who try to mislead others. But because we have over 46 million Ugandans out there who are interested in having their disputes with the state adjudicated properly, we will pull back for now and come back better and stronger. We will be back. Let the bill be stood over.
Now, Honorable Minister, withdraw it formally.
Madam Speaker, I need some guidance from the chair, because our intention was to have it stood over. I will oblige your guidance.
Madam Speaker,
Madam Speaker, there is nothing like standing off a bill.
Madam Speaker, the issues of controversy are very clear to us now. I beg Madam Speaker that we stand over and not withdraw. We stand over the issue and reconstitute and reconvene to discuss the controversies.
Right, Honorable Speaker.
Procedure.
The bill is drafted badly. The bill is drafted badly.
Madam Speaker, we would like to thank the House.
Honorable Love, come back to your seat. No, you come back to your seat. No, come back to your seat.
Madam Speaker, I would like to thank the members of the committee for enriching the government bill. I'd also like to thank members of the House, including the minority. The matters of contention are now clear to us. And since you have assured us of time in this House, I wish to move under Rule 140 of the House Rules to withdraw the bill.
Thank you, thank you. I put a question that the National Tribunal Bill Amendment, the National Tribunal Bill 2024 be withdrawn under Rule 140. Those in favor say and the contrary nay. The ayes have it.
Item 4 on the order paper. Bill second reading. The National Coffee Amendment Bill 2024.
Honorable Minister, honorable members, yesterday the bill was laid on table. The report was presented, both reports. Honorable members, Jonathan, we have finished. Jonah, so the bill the bill on coffee is for the debate. The debate is now open.
Sky TV, irakari abantu.
Sanyu lya kazero. Tugenda kwevuga ne kazero lino lye sanyu ly'omwaka nyabo sebo. Wanywere kazero wangule ebira. kunywa kasanikira kyolaba kyowangula mulimu pikipiki egaali enkofiira t-shirts ambuleera ne sente enkalu emotoka toyota pulimo empyatuku just kunywa kazero
wetabe musanyu ly'omwaka ng'onywa kazero kombucha drink ne kazero dawa tea kebera mu kasaanikira ky'osangamu ky'owangula musange mu maduuka mu ggwanga lyonna
just kunywa kazero